Hello, my friends. In our last session of Advocates Continuing Legal Education, we had discussed how to prepare arguments, how to make preparation for argument. Today, we are going to discuss how to actually argue a case before a court. Some of you will ask, what is there to learn? I am fully prepared with the facts, with the law, with the case law. I'll go to the court, place the facts, law and the case law. If I have a strong case, I will win. If I have a weak case, I'll lose. What part does advocacy play in this? Some of you may have faced a situation. You argue a case before the judge. Judge did not appear convinced. He was going to pass an order against you. Somehow the matter was adjourned. You engaged a senior. Next day, senior went to the court and argued the same facts, same law, same case law which you had argued. The judge totally changed and passed an order in your favor. You will say, or some of you will say, this is not advocacy. This is face law. FACE, face law. I will not say that there is nothing called face law. There is face law, and somehow it does work. A junior prays for adjournment. Adjournment is not granted. You argue for 5 minutes, judge stops you, saying that you have no case. The judge allows the senior to argue for 30 minutes on the same facts and law. You make a prayer for urgent listing. Prayer is not allowed. Senior makes a prayer for urgent listing. It is allowed. These things do happen. They will happen. This is part of the game. But to my experience, except in a very, very, very rare few cases, face law does not affect the final outcome of a case. You will ask, I argued a case, judge was against me, the senior argued a case, judge was totally in his favor. You will ask, what is this? This is obviously face law. I beg to differ. The judge was in favor of the senior's argument because the senior was a master of the art of advocacy. The judge was in favor of the senior because the senior argued the case in a much better way, in a much persuasive way. He placed the facts more convincingly. He placed the law after properly analyzing it. He placed the case law and was able to satisfy the judge that that particular case law was applicable to the facts of your case. He was able to reply to the judge's questions properly and convincingly, and he was able to meet the points raised by the other side much more convincingly and persuasively. In one word, the senior was able to think on his feet, while you have not yet learned the art of thinking on feet. The most important part of advocacy is the ability to think on feet. In spite of all your arguments, when the judge raises a doubt, you are not able to give a proper reply. When the other side raises a point, you are not able to give a proper reply. You are not able to meet the point. You have to be prepared to answer the unexpected. You get a few seconds time to answer the unexpected. You are not able to do so because you have not developed the art of thinking on feet. Quite some time back, I had attended a seminar on advocacy which was addressed by one of the senior most advocates with all India fame. He said, you can never develop the art of advocacy unless you practice it. If you make notes of your argument sitting on a table, you will not develop the art of thinking on your feet. He said, the best way to develop the art of thinking on feet is to stand before a mirror and practice your argument, thinking that you are actually addressing the judge. If you do it for 15 minutes every day, after a few years, you will have your own case law. Judges will start respecting you like they respect the seniors today. But practice, practice and practice. Practice standing on your legs. and you will be a good lawyer, a famous lawyer, a successful lawyer. Today, we could not cover all aspects of the art of advocacy, and I'll try to cover the same in another part of the argument. Thank you.